Now, South African actors say changes to the copyright law would give them residual income in the form of royalties during the COVID-19 outbreak and lockdown. But the European Union and the United States are putting pressure on President Ramaphosa to ditch the contentious copyright amendment bill. The 28th of March marked a year since the bill was approved by Parliament, as well as the National Council of Provinces, clearing the way for the President to sign it into law. He has yet to do so. Reporter Aviwa Mtila is on that story for us this afternoon. You've just spoken to the SA Guild of Actors. What have they told you?
Well, basically, Jeremy, they're saying that during these testing times of COVID-19 pandemic, essentially with work getting scarcer and scarcer, they would be in a position, had that bill been signed by the president already, they would be in a position, in fact, to earn now with those provisions in the bill, which would see them, in fact, earn some of the royalties of previous work that they've already done before. In fact, I got a chance to catch up with Jack Devananara, who is the chairman of the South African Guild of Actors, who basically saying that if that bill was in place, they would be earning through royalties now, and in fact, it wouldn't be so bad. But let's listen to what he had to say.
In this country, actors do not have a statutory right to earn royalties, unlike actors around the world who do have that right. South African actors do not have the protection that's afforded to them by the statute. And I suppose the biggest, most important aspect, speaking in economic terms, is that South African actors will then have the right to earn royalties. And royalties basically mean that every time a show, a TV series is shown around the world, it's sold to other territories, that the actor would earn a percentage as a residual income. And in these terms, that's what's known as royalty, and we will be able to earn something for the exploitation of our work. And it's interesting to see, though, that right now, while collective management organizations are making royalty payments for musicians, for composers, actors who are no less a part of the creative economy have been denied that right for so long. And it's a desperate situation now, especially when so many actors are stuck due to restrictions of COVID-19, unable to earn an income, desperate for grants, desperate for food, desperate to try and meet our commitments to pay rent, to keep our households going, that we are unable to earn an income from work that we've already done.
All right, so the president, as I mentioned, Aviwa, is facing international pressure not to sign the bill, though. Why?
Well, you'd understand that just a month after that bill was in the president's desk for signing, in April already last year, the International Intellectual Property Alliance in the United States basically spoke to the authorities in the United States, raising their grievances that if this bill was to be passed through, copyrights, in fact, U.S. copyrights would be infringed upon. So essentially, authorities in the United States looked at broader implications, even with trade deals, in fact, with South Africa. Some of the topics that I've touched on with Stephen Hollis, who is a copyrights lawyer, who basically says that even investments, other investment, not only just in the entertainment and movie space and publishers, would be impacted if, in fact, the president was to sign through. You'd understand that it's a double-edged sword because this bill would, in fact, give the users more rights than the actual, for example, authors of books, who, if it were for educational purposes, their work would actually be given out for free in some instances. But let's listen in on Stephen Hollis, a corporate rights lawyer, and what he had to say on that.
In America, there was a complaint brought by the International Intellectual Property Alliance called the IPA. Now, they represent, they're a trade association that represent all the major players in America in the creative industries. So, for instance, the movie business, you've got the publishers, you've got the music companies, the gaming companies, etc., saying, we feel that if this bill is going to be passed into law for some of the reasons we discussed, we're going to lose a market in South Africa because we won't be comfortable anymore to actually invest in that jurisdiction, because we won't recover our high-level investments and we won't be able to enforce our rights against users who will have too many rights to access for free. Okay? Now, that complaint was brought to the office of the USTR, which is the United States Trade Representative Office, and for them to investigate whether this bill, if signed into law, would in fact place South Africa in breach of its obligations in terms of the AGOA trade deal. and the GSP, which is a generalized system of preferences, duty-free access to American markets. Because what they're essentially saying is, in terms of that AGOA agreement, unless you provide adequate intellectual property protection for American companies, then you're in breach of that agreement.
All right, Aviwe Mtila, thank you very much.